Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Ben Grau, and a Louisiana construction lien law expert. Today's webinar topic is don't sign a release unless it says this one thing. So without further ado, I'd like to introduce the fabulous Ben Grau.
Thanks, Jessie. Appreciate the opportunity to be here. I'm looking forward to this discussion. As Jessie said, my name is Ben Grau. I'm an attorney with the law firm of Simone, Terragine, Smith & Redfern in New Orleans, and we specialize in construction law here in Louisiana and in the surrounding states. So we're going to talk a little bit this morning about a release in a construction project, and specifically a lien waiver. And so the title of this presentation is Don't Sign a Release Unless It Says This One Thing. And there'll be an opportunity for questions at the end, and you'll see there's a chat button if you want to leave some questions. We'll get to those at the end. Now, turning to our topic, don't sign a release unless it says this one thing. And I'm just going to jump right in and give you my answer to this question. And the answer to the question from my perspective is you want to make sure the one thing that is included in your release is that the scope of the release language is appropriately defined and the claims are adequately preserved. That is of critical importance when signing any construction document, but specifically when signing a lien release waiver. The topics I'm going to talk about just briefly will be the purpose of the release and lien waiver, the scope of the release language, as I said, and the scope of any other agreements that are included in the lien waiver. So what is the purpose of a release? As you know, it's obviously from your perspective, from the contractor or subcontractor's perspective, you probably think of it as the document that I need to sign in order to get paid on the job. And that very simply is what it is. Though it does carry with it significant legal consequences. And so it's important for you to remember that a release and lien waiver is a formal, legally binding document. The document states that the claimant, the contractor, subcontractor, or supplier, has received payment for services rendered. And as a result of receiving that payment, the claimant releases the payor and possibly others from claims and waives any rights to file a lien on the property. So bear in mind, again, that it's a formal, legally binding document. Many people don't realize that the lien waiver will trump or override any language that might be included in their contract. So oftentimes people might think, it's no big deal if I sign this lien waiver, I don't have to agree to everything set forth in the document, or if it's inconsistent with my contract's going to govern. That is not true. The lien waiver itself constitutes or can constitute a change or an amendment to the contract itself, and its terms will override the terms of the contract. So it's very important that you understand what is being released in the lien waiver. That brings us to the scope of the release, the most important thing that's set forth in the lien waiver document. You need to first consider whether your lien waiver is a conditional lien waiver and release or an unconditional lien waiver and release. And so what does that mean? Well, a conditional lien waiver is conditioned upon certain events happening. Generally speaking, a conditional lien waiver is conditioned upon receipt of payment. And so you'll sign a conditional lien waiver and submit it to a contractor with your pay application before you actually receive the money. And the lien waiver will be that upon receipt of the money set forth in the pay application, then the contractor does release certain rights, certain claims. An unconditional release, on the other hand, is effective immediately upon execution of the document. So it's not conditioned upon having actually yet received that payment. And that's important to understand whether you're signing a conditional lien waiver or an unconditional lien waiver, because it determines when your release becomes effective as to the owner, and it also determines when your other obligations, such as indemnity obligations, become effective. And you can find yourself in a situation where you're indemnifying an owner for certain claims prior to payment actually having been made, or at least you're faced with a demand for such indemnification, and then you have to address that in the context of your lien waiver. Oftentimes, too, what happens on construction projects is you'll submit a conditional lien waiver with your pay application, and then you'll replace that lien waiver or provide a subsequent unconditional waiver upon receipt of the funds. That's a perfectly acceptable process, but it's important for you to bear in mind, if you're being asked to do that, you need to scrutinize the language of both lien waivers, not just the conditional lien waiver that you sign first, but you want to make sure that the unconditional lien waiver, again, has language that's appropriate and acceptable to you. So, the scope of the release, the most important thing contained in the release. What does the release language say you're giving up as a contractor or subcontractor on the job? Oftentimes, we will see contractors and subcontractors sign lien waivers that have very broad general release language. You want to try and avoid that whenever possible. You want to look at that release language and you want to condition or limit the release language to claims, if you can, to payment claims only. And you also want to limit that release up to the amount of the payment being made. So if you're receiving a partial payment, you only want to release the owner or the contractor, if you're the subcontractor, for claims up to the amount of the payment being made. By doing that, you will be preserving other claims that are over and above the contract amount. Oftentimes, where contractors and subcontractors get tripped up on this issue is when it comes to retainage. You want to make clear, by limiting it to the amount of the payment being made, that you're not waiving any claim for retainage that may not yet be due and that may be withheld from your interim payments. You also want to understand whether the release that's being provided is an interim release or a final release. That is, are you releasing claims up to the date of the execution of the lien waiver, or are you providing a final release for any and all claims on a particular project? You don't want to give a final release on a project where you're not yet complete or you haven't received your final payments. And then, as I said, you want to make sure that the release language specifies as best you can, is it a release of all claims or is it a release of only payment claims? And this ties in with the next issue, which is preservation of claims. So you want to make sure not only is the release language itself limited to the claims that you want to be releasing on the project, which generally at the point in time when you're being asked to sign lien waivers, it's because you're being paid for interim payments for work on the project. You want to limit that release language to the amount of that payment and that payment only. You also want to make sure that you've got language included in the lien waiver document that preserves any claims that you may have made or may have incurred as of the date of the lien waiver. And so you want to make sure specifically that you are reserving your claims for change orders. You've got pending change orders out there. You know you've been impacted on a job. There's been work done. Perhaps you've gone ahead and performed that work before you have an executed change order for whatever reason, and you've got a pending change order out there. You want to make sure that you're preserving your claims for those pending change orders. If you've submitted any claims on the project at that point in time, delays, inefficiencies, differing site conditions, all of the myriad things that we see claims for, if those claims have been submitted to the contractor or the owner, you want to make sure that you're preserving those claims. You want to specifically identify those to the extent you can in the lien waiver. You want to identify it with an attachment. We see that very often where you'll say preserving all claims set forth on Exhibit A, and you'll attach a one-page document that'll have all of your open change orders on the project, any REAs or other claims or requests for adjustment on the project. You also want to make sure, to the extent you can, that you're preserving unknown claims. So you may have been impacted on a job prior to the execution of the lien waiver, but you don't, that hasn't manifested itself to you in terms of actual damages yet on the project, but you're not quite aware of it for whatever reason. And so there are impacts that have happened, but you're not aware of those impacts yet on the job. You want to make sure that you're reserving and preserving those claims as well. And so the biggest piece of advice that I can give on the lien waiver is that you need to make sure that both the scope of the release and the preservation of the claims are explicit and they're consistent with what you want out of the document. Many people believe that they cannot change a lien waiver, that the language is either statutorily drafted and so it says what it has to say, or it's being forced upon them by the owner or the contractor. That is not true. It's a legal contract, just like any other contract, that can be amended, revised, clarified to show the intent of the parties. And so you need to make sure that you're doing that and you're preserving and protecting your rights under this contract. On that point, I'll also note that many times the lien waiver document or a Templar example of the lien waiver document is included with the original contract. So when you sign your contract, it'll say, each month you'll submit a pay application along with the lien waiver in the form attached here to this contract. You want to look at that at the outset before you sign that contract. If it's got a mandatory lien waiver document, you want to look at it then, and you want to try and negotiate that document to make sure that it's providing you with the protections that you need. But even if you don't do that, even if there's a form document attached and you just don't look at it for whatever reason, when it comes time to actually sign the document and submit it with the pay application, there's still an opportunity for you to negotiate that document and make sure that it says what you needed to say. I want to turn for a minute to the rest of the lien waiver and what else is included in the lien waiver. Oftentimes, in addition to releasing claims, a claimant will make an affirmation that all lower tier subcontractors, suppliers, material men have been paid or will be paid. Commensurate with that, there'll also be indemnification language that'll say that the claimant will indemnify the payor and possibly others. So if it's a subcontractor to a contractor, it'll oftentimes include the contractor, the owner's surety, perhaps other people as well, as part of that indemnification obligation. And so this, again, is a legally enforceable agreement and a legally enforceable affirmation that you're making. So you don't want to agree or sign something that's not true. So if you haven't paid your lower tier subcontractors, you don't want to sign an affirmation saying that you have in fact done that. You want to address that with the contractor or the owner right then and there. You want to explain to them if there's a reason why you haven't paid them, then you want to say what that reason is. If you're withholding funds from a lower tier sub or supplier for some reason, you need to make the owner and the general contractor aware of that. If not, you're signing an affirmation saying that you have in fact paid them. If that's not true, the other party may have recourse against you. They rely on an affirmation making payment to you, and then they get stuck somehow down the road making a double payment or the like. They can come after you potentially for damages in addition to the indemnification obligation that you likely owe them. You also want to make sure that you understand if there are any other agreements that are included in the lien waiver. It's not very common or often, but once again, it's a legally binding contract. So you want to make sure that there's not some extraneous language included in the lien waiver that obligates you to perform or undertake additional obligations that you weren't aware of. Finally, I want to emphasize that these rules or guidelines that I've just given you with respect to the release language contained in a lien waiver would equally apply to other documents that a contractor or subcontractor is asked to execute during the course of a project. The most common one, or the one that would be most glaring, would be a change order. And so just briefly addressing change orders, Oftentimes, a change order will have similar release language to a lien waiver. It will say that the contractor or subcontractor agrees that the amount set forth in the change order or the number of days provided in the change order constitute full and final compensation for the change. You want to make sure that that language is sufficiently limited in scope to protect you as the contractor or subcontractor. If it's a single change order providing for additional compensation for a single change, you want to make sure that that change order is limited to that specific issue and that specific change. Oftentimes, a change order will say it constitutes full and final compensation for this change and any other change that has occurred prior to the date of this execution. And so again, we've had situations in litigation where a subcontractor is saying, well, I had pending change orders out there for additional items at the time that I signed the change order, and the contractor or the owner is arguing, but you've waived those claims by executing this other change order through a particular date. And so you want to be mindful of every document you sign in a construction project and all of the releases that are set forth therein. Finally, I just have one example here of a partial release. This is a partial release given by a subcontractor to a contractor. And so really, it doesn't have to be complicated. It doesn't have to have a lot of legalese or verbiage, but it has to specify what it is that the contractor or subcontractor wants to release as part of the document. So here you'll see the second paragraph. It reads, subcontractor in consideration of the sum of and the specific amount of money which is being paid, which represents partial payment for materials and or labor in said amount, again referring to the specific dollar amount, receipt of which is acknowledged, releases its claim of lien, and right of lien for said amount that it has against the contractor, owner, and the project. So the key language here is that phrase for said amount. You're only releasing the contractor, owner, and the project for the amount of the payment. And so this is a specifically limited release that's being provided. But then we go one step further and not only limit the release, but make it explicitly clear what is being preserved. Subcontractor specifically reserves its rights as to any remaining amounts owed, including retainage, pending change order requests, and any other claims, whether known or unknown. And so again, that language is sufficient to preserve those other claims. You want to go a step further, belt and suspenders, you can say, including those claims set forth on Exhibit A, and append to that a list of open change orders or a list of open claims on the project. And then finally, the last paragraph just sets forth, again, the representations and warranties that are being made. Subcontractor represents and warrants that all persons or entities who have furnished labor or materials subcontractor in connection with the work performed through the date hereof have been paid all amounts to which they have been entitled. Sometimes we'll add language that says have been paid or will be paid within a certain period of time from the amounts that or the amounts to which they're entitled. And then there's the obligation to indemnify, which again is pretty standard. When a general contractor pays you as a subcontractor, you're obligated to pay your lower tiers, and you've got to protect the general contractor and the owner from those claims. But again, you want to be clear, what are you indemnifying them for? Is it specifically limited? Is it limited to the amounts of the payments set forth herein? Is it limited to the amounts that are have been billed for in the pay application to which this lien waiver attaches? And so this is just some example language. Again, it's not statutory language. It can read differently. You can use different words. You can choose different things, but it doesn't have to be complicated. But it does need to ensure that the scope is limited exactly to what it is that you are willing to release as a subcontractor, limited to the amount of the payments, to the claims existing as of the date of the lien waiver, and specifically reserving and preserving any claims that you have. And so with that, that's my brief discussion on the one thing that needs to be included in a release for a construction project. Thank you for your attention, and I'm happy to answer any questions that anyone may have.
Perfect. Thank you so much, Ben. I appreciate that. Can you go to the next slide for us, please?
Oh, sure. I'm
Thank
sorry.
you. No, it's okay. Perfect. That was amazing, though. I really do appreciate it. That was some really good information. The key is make sure you guys are knowing what you're signing before you sign it. Okay. As he said, there's lots of specific pieces of information that you should really make sure is in there that's going to benefit you. I think you actually just covered all of this in the last slide, but this question came in right before that. I'll go ahead and pose it for you. It was saying, is there any certain language that you're referring to preserve the claims for change orders or unknowns? And you just had that on that last slide, pardon me, where it had a subcontractor specifically reserves its right as to any remaining owed amounts, including retainage pending change order requests and any other claims, whether known or unknown. So as Ben stated, that language is going to be able to be there to protect you. So make sure that you have that in there to make sure that it's the right document that you're wanting to sign. All right, and then then the other question that came through, Ben, it was, if I make a mistake, what is the recourse I have if I do sign the wrong type of release? What can I do?
Sure. So, I mean, the best thing for you to do is if you make a mistake, as soon as you realize there's a mistake made, you want to address that. You want to address it with the other side and say, you know, I signed this in error. As you know, we had pending claims out there. We didn't intend to give up those claims in this document. You want to do that as soon as possible. In Louisiana is an intent state, so the document has to have the intent of the parties. If there is a mistake, the document can be conformed. It can be modified to the actual intent of the party, but there are ramifications to that, and so you want to do it sooner rather than later. You don't want the other side to rely to their detriment on a document that you know contains a mistake in it. And so, and that would be my advice for anything, actually, in terms of whether it's a lien waiver or a change order or any other document, just in dealing on a construction project. If you realize that you've agreed to something formally or informally that is not what you intended or not what you is in your best interest, you need to address that as promptly as you can. The documents can be amended for sure, even though you signed it, so you can do an amendment or a clarification with the other side, with the contractor or the owner, saying, you know, even though we signed this document, this is what we intended, or we modify the document in such a way. So you just want to address it. That's the number one piece of advice. As soon as you realize there's a mistake, address it. If the other side won't give you any relief from that, at least you've raised the issue. If it becomes an issue down the road, you've got documentation that that was not in fact your intent, and you alerted them to it, and you'll make sure that you don't make that same mistake on the next lien waiver or change order document.
Perfect. Thank you so much. Well, hopefully, if you do make a mistake, hopefully the other side is able to work with you and rectify that situation. And like Ben said, if they're not, at least you have documentation that you are saying, hey, wait a minute, that's not what I intended. And hopefully that will help you in the long run. Those are the only questions that have come in so far. If anyone does think of a question that wasn't addressed, please feel free to reach out. I'll make sure that I answer any questions as soon as possible for you. Can you go to the next slide for me, please? All right, so who is ready to win a gift? We're testing your knowledge. If you feel like you know the answers to this information, go ahead and put it in our chat or the questions section, and I will go ahead and send you guys out a free gift. The first question is, when is the deadline to file a notice of non-payment in Louisiana for subcontractors and suppliers on state projects? And then the other question is, if a notice of contract was filed on a commercial project, then the lien must be filed within how many days of substantial completion? If you feel like you know those, go ahead and enter them into the chat, and I'll send you guys out a little gift. Can you go to the next slide for me, please? All right, wonderful. Here are some of our SunRay resources to help you guys stay organized, know your deadlines, secure your lien rights. So go ahead and scan that QR code to access these incredible resources. We've got deadline calculators, project information sheets. We even have state lien laws by state on there. So if you're working in a nearby state that you haven't worked in before and you don't know the lien laws, click on it. You can click on the state, say I'm working commercial, I'm a subcontractor, and it's going to tell you what type of documents you're going to need in that state. Each state has its own lien laws, so every document and deadline can be different. So make sure you're checking that out to protect yourself. Go ahead and go to the next slide, please. All right, so we have a new service at SunRay. We are going to start helping with your collections. We have SR receivables. So if you are stuck and you're not getting paid, give us a call, send us an email. We can kind of go over what we can do to potentially help you. So we'd love to be able to hear for you and help get you guys paid. And then the next slide, if you don't mind. This one is just to give us some feedback. So scan that QR code. It helps us give us that review, make sure that we can improve our webinars, answer any other pertinent questions and conversations that you guys would like to have, and we get this content out to more contractors and suppliers like yourselves. And then the last slide, if you don't mind, please, Ben. Wonderful. With that, that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. And thank you again, Ben. You were incredible. And I hope you all have a wonderful and beautiful sunny day.